Good morning, everyone. We're glad to have you here. Probably happier for you to be here than you are to be here. As you know, the Court of Appeals is one court, even though we sit in three different places. So today we have Judge Christy Davis from the Eastern Section, and we are delighted to have you and look forward to great legal insight.
For me?
Yes.
Oh.
Yes. And you didn't think I was talking about Judge McBrady, did you? We have 4 cases on the docket this morning, and we will hear them in the order in which you see them on the docket. If there are no announcements or introductions, and seeing none, would you please call the first case?
Cherokee Fiber and Associates, Inc. versus the Commissioner of the Tennessee Department of Revenue.
Good morning, Your Honors, and may it please the Court. My name is Tyler DeWitt, and I represent the appellant, Cherokee Fiber and Associates. This is a tax case, so...
Do you want to reserve any time for rebuttal?
Yes, Your Honor. I would like to reserve 5 minutes for rebuttal.
5 minutes.
And speaking of time, perfect segue,
Yeah.
we'll be looking at the calculation of the 90-day period to file suit after a final tax assessment under TCA 67-1-1801 subsection B. And really, it's a fairly straightforward issue, I think, that's before the court this morning. And it's a matter of calculation. We know that the statute says there's 90 days after a tax assessment becomes final to file suit in Chancery Court. But how is that 90 days calculated? We know from previous cases in this court's precedent that that's not always a common sense answer. In fact, we would argue, Your Honors, that Tennessee Rules of Civil Procedure 6.01, which corresponds with TCA Section 13102, directly is on point here and applies to the actual calculation of this 90-day period to file suit. And just to kind of refresh the court on the facts here, this is a case where the complaint was in the eyes of the Chancery Court, and the state of Tennessee, the Department of Revenue, was filed a day late and maybe $1 short. But from the perspective of Rule of Civil Procedure 6.01, Your Honor, it's a different outcome. This would have been a timely filed complaint. And so when you look at Tennessee Rule of Civil Procedure 6.01, it excludes the first day of the event giving rise to the calculation of a statute of limitations or of a time period to actually commence suit. And if you look in the Chancery Court's opinion, and even in the brief of the appellee, they consistently argue that the 90 days is measured from the date of the actual final assessment. And we know from Rule of Civil Procedure 6.01, it would be measured from the next day. If you look at the direct language of 6.01, it says, and I'll try not to read the whole thing, but I think it's relevant just for the court's attention here. In computing any period of time prescribed or allowed by these rules, by order of court, or by any applicable statute, the date of the act, event, or default after which the designated period of time begins to run is not to be included. And so this is a very key, part of Section 6.01 of the Tennessee Rules of Civil Procedure, because the Chancery Court, in fact, seems to have done the opposite, and that's what the appellee is arguing here as well, that 90 days is measured from the date of the final assessment. I'd want to point the court's attention to Sanders v. Traver. It's a Tennessee Supreme Court case that I believe bridges Section 1801 of the tax code to Tennessee Rule of Civil Procedure 6.01. And this case stands for the proposition that when there is no specific statutory provision regarding how to compute an applicable time period, as what we have here in Section 1801, then 6.01 of the Rules of Civil Procedure would apply. and its corresponding statute, TCA 13102. And in fact, the court would say it must be applied. And this, again, evolved in the Sanders v. Traver case, it involved a statutory framework similar to the tax code, where it's sovereign immunity. The state has to consent to be sued. It's an exclusive remedy. It sets forth exclusive jurisdiction, just like our tax code does. But again, if it's silent as to the actual calculation of a specific time period, which mirrors Section 1801 perfectly, then we have to go to 6.01 of the Rules of Civil Procedure and its corresponding statute. I think one case that I think really illustrates what I'm saying here, because I'm a visual person, it's kind of hard to like think about dates and times and all this stuff kind of talking out loud here, but there's a case that was decided by this court in 2013, Spates v. Howell, and it really applies the calculation that I guess I'm pushing forward before the court today. Now, this interpreted the 1-year statute of limitations for filing suit in TCA 283104, which is for healthcare provider actions, basically medical malpractice. And in that case, they measured the 1-year time period to file suit from the day after the event giving rise, just like 6.01.
They don't really say how they calculate it, do they?
They don't, Your Honor. I think you certainly have to, go do the calculation yourself. I guess if you look at the way they calculated the dates, the relevant period of time that would give rise to filing suit in that case started on April 8th, 2011. So if we apply Rule 6.01, then you would measure 1 year from the day after. And that's exactly what the court did, because they determined in their opinion, now this is in the text of the opinion, well, all of this is, it's just you have to, they don't expressly summarize it, in this way. The statute of limitations for, the time period for filing suit expired on April 9th, 2012. Now, if you applied the calculation, the logic that the government's arguing and what the Chancery Court did, you would get to a different result in Spates.
I don't think you would. I went back with my computer has that calendar,
Right.
And it has this calculate dates function in it.
Right.
And I went back to the 2011 year and went to April 8th of 2011, calculated 366 days later, because it was a leap year, and it ended up with April 8th of 2012. April 8th of 2012 was a Sunday. So under the rules, you move to the weekday, Monday. So you still get to the 9th, doing it the way the state calculated.
Right, Your Honor.
Wouldn't you? Am I right?
And I don't have the calendar in front of me, Your Honor. I mean, I certainly don't dispute that, I guess. But I do think that one little wrinkle in the analysis the court used there, though, is there was a leap year. And I don't know if you mentioned 366 days or not.
I did.
But that would be a factor here. And so, Your Honor, we would submit that, again, Spates does support our position here, and that if you did apply the actual 6.01 calculation that Spates used to this case, we would arrive with a final deadline to file suit or to file a complaint of November 2nd.
But again, Spates didn't spell out how they did it.
They didn't, right? But and I know that's less than ideal here, as we're kind of having to reverse engineer and see how the court, got to the result that it did. But again, we would argue that applying that same logic here, just the facts what we're arguing, when you apply 6.01 and you draw the inferences from that case to this case, we arrive where November 2nd, where the actual date that the complaint was filed, is timely.
Okay.
I just want to make sure that I understand your argument. The date that the operative order was filed was August the 3rd, correct?
Yes, Your Honor.
And you say we don't count August the 4th.
Well, so the 90 days, what we would argue is the 90 days begins to run starting from August 4th.
So you don't count the 4th, you start with the 5th.
Well, you would start with the 4th. So, and that's where it gets confusing, because, Your Honor, you mentioned the online
But
calculators.
the 4th isn't day one.
The 4th
under your calculation.
Is not. right?
The
Well,
5th would be.
Well, the 4th really would be day one. I mean, because
Well, then that messes you up math-wise. The math ain't mathin' for you there.
well, I mean, and that's where you get into, and I know this is, not to get into a math problem here, but that's where, you talk about these online calculators. It depends on where you measure, the starting point of the day, And so, I mean, I'm trying not to laugh explaining this, Your Honor, but that's
we all
really
went to law school to avoid these mathematical problems, and here they are.
Same here. I happen to also be a CPA, so man, I should be better at this. But at the end of the day, Your Honor, we would argue that when you go and you apply the Spates reasoning, you go from this 90-day period. It starts on August 4th, certainly.
But you don't count that.
You know,
When do you say is day one for your 90 days?
well, I think day one begins on August 4th.
So that's one, and then you go 2, 3, 4, 5 from there.
Yes, Your Honor. It's, and without having, I guess, like a giant calendar behind me, we would submit that when you do that analysis, you get to November 2nd as being 90 days.
When you say it begins on August 4th, but that's not, as I understood your arguments, I guess, I understood you to say you don't count August 3rd, and you don't really count August 4th because that's when the counting all begins. So day one is actually August 5th. Day two is the 6th, et cetera.
Your Honor,
Is that not right?
I think that's a fair way of summarizing it.
Okay.
It's and not to sound like I'm talking on both sides of my mouth. I mean, it kind of is day one, but not really. I think the way you summarize that, Your Honor, is an
Okay.
accurate summary.
Thank you.
Thank you.
Your time is up.
Good morning, and may it please the court. My name is Laurel Hall, and I'm here on behalf of the state. Your Honors, the issue before us today is simple. It involves a tax assessment challenge that was filed late. The case was dismissed by the Chancery Court on April 19, 2023. The court granted our motion to dismiss that argued the complaint failed to adhere to the requirements under the taxpayer remedy statutes. Those requirements being that the complaint should be filed within 90 days from the date the assessment becomes final, with a copy of the notice of proposed assessment attached as an exhibit, and signed by the taxpayer under the penalties of perjury, affirming that the assessment being challenged is unjust, illegal, or incorrect, and that the suit is brought in good faith and not solely for the purpose of delay. Here, plaintiff's complaint was not filed within the 90-day filing period. It did not include a notice attached as an exhibit, and there was no signed verification. Now, at the hearing before the Chancery Court, plaintiff argued the complaint was timely and it was the commissioner who was simply miscounting. But Judge Perkins disagreed. He held the complaint was filed on the 91st day, therefore depriving the court of subject matter jurisdiction and dismissing the matter. He rendered the other issues moot given the complaint was untimely. Plaintiff appealed and has now made these same flawed arguments before you here today, mainly that the deadline ran on November 2nd, 2022. It's the state's position that the deadline ran on November 1st, 2022. So the difference can be contributed to when you begin counting the 90-day filing period. And as you touched on this earlier, Your Honors, the state's method of counting starts from the date of the triggering event, August 3rd, and counts August 4th as one. Plaintiff's method of counting starts the day after the triggering event, August 4th, and counts August 5th as one. And to put it in perspective, under plaintiff's method, the triggering event is considered -1, the following day is 0, and the day after is finally 1. As discussed earlier, Tennessee Rules of Civil Procedure 6.01 and Tennessee Code Annotated 13102 provide some guidance on the computation of time and are essentially identical in nature. Both state that the triggering event should not be included in the calculation. And the state abides by this since August 3rd is considered 0. However, neither the language in the statute nor the language in the rule support plaintiff's argument that you begin counting 2 days after the triggering event. And when we can really consider the implication of plaintiff's argument, we are talking about extending a statute of limitations. And this is simply not within the court's authority. That power relies with the legislature. And opposing counsel is trying to argue that one deadline with no explanation in Spates v. Howe provides some loophole that allows him to violate the statute of limitations, but we agree with the court's interpretation in that case. And we agree that we don't believe the appellate court intended to extend the statute of limitations when it issued that decision. And although plaintiff is trying to complicate things, this really is a straightforward issue. He filed the complaint late, without a copy of the notice, and without a signed verification. To allow plaintiff to move forward and proceed on this claim despite not following the requirements under the taxpayer remedy statute would directly violate the state's sovereign immunity. For these reasons, we respectfully request the Chancery Court decision be upheld. And if there are no questions, I yield my time.
See no questions. Thank you, General.
Thank you.
Your Honors, I want to clarify a couple points, if I may, and excuse me if I did not eloquently express this earlier when we asked about the day one starting point from August 4th. I want to be very clear in saying, in terms of our position here, that August 4th is actually day 0 of the calculation period. In fact, opposing counsel mentioned, and this is what I think had started our argument with, is the fact that they're arguing that the 90 days starts from August 3rd, which is just completely in contradiction to 6.01 of the Tennessee Rules of Civil Procedure.
I think they're arguing August 3rd would be day 0.
Right. And Your Honor, I would submit that August 3rd being day 0 would represent that day being part of the calculation. Because day 0, when you say day 1, as you asked earlier, Your Honor, that's assuming an entire day's already passed, right? We go from 0 to 1 to 90. And so if we start at day 0 at August 3rd, then August 3rd is, for all intents and purposes, being counted as a day by that application. And going back to, Your Honor, the court's comment on the Spates case and the calculation and how that date fell on a Sunday, I would also want to point out that by our calculation, while yes, if you did apply the government's rationale, it would land on a Sunday and then move to the following Monday. By our calculation, it just went straight to Monday. And I think that's exactly what the court applied in that case, Your Honor. And so I think— But
we don't know.
Well, Your Honor, I would submit that there's certainly, I think, an inference there that the court was applying 6.01. In fact, I would even say—
Are you suggesting that you look at the actual specific time of the event and then add 24 hours and don't include that 24-hour period? Is that what you're saying?
Well, Your Honor, I would say, going back to the text of 6.01, right, in computing any period of time, the date of the act, event, or default after which the designated period of time begins to run is not to be included. So that day is not to be included at all from the express plain language of 6.01 of the Rules of Civil Procedure. And so we would submit that when you start any calculation, you don't start from 1, you start from 0. And so 0 is, presumably 12:01 a.m. on August the 4th. And then 90 days accrues from there. And so it is a simple matter, but at the same time, I think this is why we have Rule 6.01 of the Rules of Civil Procedure, because what happens if you receive the final assessment at 6:30 p.m. on August the 3rd, right? I mean, I think the rule, clearly the intent here is to allow adequate time for everything to be measured from a consistent starting point. Some people, maybe on August 3rd, you get it at 8 o'clock in the morning when the mail runs.
I would expect 90 days would be adequate time to petition to court.
Absolutely, Your Honor. I certainly would agree with that and respect that position. But I think when you apply 6.01 just literally to this, you know, to the facts at bar here, Your Honor, I think we get November 2nd as 90 days, because going into 6.01, the first day, August 3rd, that's not even considered. August 4th is day 0. We calculate from there. Just like the court reasoned in Spates v. Howell. They did specifically mention Rule 6.01 of the Tennessee Rules of Civil Procedure, and that the first day is excluded. The court, in that opinion, the reason I do say that the decision supports our position, Your Honor, is because the court did say August 8th, 2011 was the actual final date from which, again, if you apply the government's position, 90 days would be measured from. But they specifically said that date is not what's considered. April 9th, 2012 is when it starts, and that's where they applied 6.01 of the Rules of Civil Procedure. So, no further questions, Your Honor. We would respectfully request that this court reverse the Chancery Court's decision and apply 6.01 to determine that this complaint was timely filed, and proceed accordingly. Thank you.
Thank you very much. Thanks to both of you. Would you call the next case, please?